You're watching Truth versus Hype. The CBI's investigation into allegations of corruption in the allotment of thousands of crores of captive coal has always been a test of its independence, since the Prime Minister was holding the coal portfolio for the period that it's probing. And so when news came that the government might have tampered with the CBI's report on the coal scam, it confirmed everyone's worst fears. Over the next 30 minutes, we'll attempt to piece together the scope of that interference, involving the Law Minister, top law officers, and even officials from the Prime Minister's office. And also ask, what is it about the role of the PMO that is making the government anxious to such an extent? The chain of events that has snowballed into a major controversy for the government began on a crucial March 12th hearing of the coal scam in the Supreme Court, when the court opened the CBI's sealed status report. The court asked Additional Solicitor General Harin Rawal, who was appearing for the CBI, if the report had been seen by the political executive. As a petitioner in the coal scam case, Prashant Bhushan was in court.
After the judges went through the status report of the CBI, they told the Attorney General, who was appearing for the government, that look, the CBI has said that there was no system. The status report says that there was no system for allocating these coal mines or for selecting the people who were to be allocated these coal mines. Have you seen this? To which the Attorney General said, no, these reports are not being shared with the government. And then the court told the CBI counsel, Mr. Rawal, that look, we would, I hope that these reports are not being shared with the political executive, to which Mr. Rawal also said, no, they are not, on which the court then said that we would like the CBI director to file an affidavit.
But even as the CBI prepared its affidavit, an Indian Express story exposed how the Law Minister had called the CBI Director Ranjit Sinha and made changes to the report. Since the Express story broke, most key players have refused to come on the record, and it's only through our sources that we've managed to piece together the extent to which the CBI's autonomy has been undermined. Sources confirmed to NDTV that on the 5th of March, 3 days before the status report was submitted to court, the Law Minister called a meeting around noon in his office in Shastri Bhavan. Attended by CBI Director Ranjit Sinha, Joint Director of CBI in charge of the investigations O.P. Galhotra, Additional Solicitor General Harin Rawal, and Attorney General Ghulam Vanvati. Just the very composition of that meeting is itself a minefield of conflicts of interest. How can the CBI meet the Law Minister of a government against whom it's probing potential corruption charges? And how can it meet the Attorney General, who represents the government in court, which opposes the stance of the CBI? But a key source present at the meeting says that a far greater transgression took place beyond just a conflict of interest. The source confirmed that the Law Minister was seen making changes to the CBI report.
Well, it is unprecedented that the Law Ministers can change facts which status reports mentioned. Law Ministers can only advise on questions of law. Law Ministers cannot alter the truth. Law Ministers cannot alter factual reports. That is something which Law Ministry and Law Ministers don't know. And according to me, we must wait for what the CBI has to say.
Sources close to the Law Minister denied that he tampered with the CBI report. They say he did call for the meeting only to decide whether the CBI report should be submitted in a sealed envelope or in open court. And that as Law Minister, he was well within his rights to hold consultations with the CBI.
I tell you, Law Minister, he is of course entitled to meet his officers. And if Law Minister has asked to CBI Director to file an appeal or something, CBI Director, there is no harm meeting with Law Minister. But how can you prove it? Even if Director would have met with Law Minister, how can you prove it that evidence has been tampered?
All I can tell you is in the 3 years which I was in office, no such occasion arose. My Law Minister never asked me to come and visit him for any such matter. CBI has consulted us as lawyers at times where they felt a particular case in law was made out or not made out, never on the factual inquiries, never ever have any comments ever been asked for on what has been found by the CBI.
In fact, it's not just the Law Minister. Questions have also been raised as to whether the Attorney General was also involved in altering the report. Charges which Mr. Vahanvati's office has denied, saying he never saw the report.
The arm's length theory, which I fiercely advocated when I was Solicitor General, and I'm afraid that arm's length theory has really not been accepted. I say it with great regret. I regret that the opinion of an Attorney General can even be overruled by a minister, which is the Law Minister, which is the, I hope the present Law Minister doesn't do it.
Another big question mark is over Additional Solicitor General Harin Rawal, who had told the court that the political executive had not seen the report even while he was present at the meeting where it was being discussed.
In this case, you see, these were oral statements which were made by the Attorney General and the Additional Solicitor General. Whether the court would take a strong view on that or not, one can't say. But certainly deceiving the court has been held on several occasions. Willful deception has been held to amount to contempt of court.